Hey guys, this is John Watts. I appreciate you joining us, and those who are joining us live, that's great. If you're watching this later, I appreciate you taking the time to watch it. My name again is John Watts. I'm a consumer protection lawyer in Alabama. And a lot of what we talk about on this channel involves debt collectors and credit reports. And so I'm always happy to try to answer questions about those. Appreciate your suggestions, your comments, your questions, because that's where we get a lot of the material from in order to create these videos. And so I've got a list up on another screen I have here of some of the questions, and I'm happy to go through those. And as I go through those, if you have comments you want to make live, you're welcome to do that. I'll pop those up on the screen. And typically when we do these YouTube lives, we have folks that will jump on and ask questions, kind of brand new questions. And I always enjoy that, because that way, if I don't fully understand the question, or maybe I need a little clarification, I can, respond to what you do, and then you type a little bit more, that'll pop up on the screen, and then we can get sort of the full question to make sure that we are really answering whatever questions that you have. So definitely look forward to any comments that you have. And I will make sure that I am set up to see the comments here. I believe I am. So let me start with kind of an interesting question that I've received from a couple of you guys. And then also I've been chatting with some other lawyers about this. And that is the topic of arbitration. So arbitration, just in its simplest form, is where in the contract you agree, instead of going to court, you will go to arbitration. Okay, so there's no judge, there's no jury, there is an arbitrator. Sometimes there's three arbitrators. And typically things happen quicker, although not always from court, but typically quicker than going to trial. And there's a different pay structure. So when we go to court, whoever files the case pays a filing fee, and that's all you pay. In other words, you don't pay for the salary of the judge. I mean, that's done through taxes. You don't pay for the jury. Again, that's done through taxes. And, that's it. I mean, it might be a month-long trial, a 3-month-long trial, or a one-day trial. It's the same cost. In arbitration, it's different. You're paying that arbitrator or the arbitrators per hour. Sometimes that's $400 an hour, $500, $700, $800 an hour. And so who pays that? Well, typically in the types of things we're discussing on this channel, consumer type transactions, normally the creditor, in other words, the company that you did the loan with or you bought the car from, they will say, hey, maybe you pay $150, $200, $350 filing fee, and then everything else they will pay. Okay. So it raises some interesting questions. What if you get sued by a creditor? I've got a question here about, if a debt buyer is suing me, but the original creditor, I agreed to arbitration with them, can I force that debt buyer who's suing me into arbitration? And is that a good thing? And what happens if they don't show up? Well, generally you can, but you have to actually read the arbitration agreement itself to know exactly what it says. So does it specifically say that the arbitration is just between you and the original creditor? Or does it say something like, if you sue us or we sue you, and then it defines we as the original creditor, and anybody working for us, anybody collecting for us, anybody that we sell or transfer, then that would cover the debt buyer if the debt buyer truly bought it. So you have to read the terms, and there's a place, typically it's on the CFPB website, I don't think it's been moved lately, where you can find basically all the terms and conditions of contracts and of credit card contracts. And so I would suggest going there. You'd say, well, I have a Capital One or Synchrony Bank or whatever it is, and find the terms and conditions, and you'll find the arbitration language. And then with that language, you can see, okay, does it look like it applies? Usually it will say that all claims have to be arbitrated, but if they're suing you for small claims or some equivalent, then it does not have to be arbitrated, but usually it gives you permission to arbitrate if you want. Now, what would happen is if you insisted on that, you would be moved from court to arbitration. And again, you have no judge, you have an arbitrator, which is usually a lawyer, sometimes a retired judge. And then the creditor would have to pay a pretty good amount, maybe the entirety of it. So, one strategy is to say, well, hey, I'm being sued for $2,000, but if the arbitration is $2,500 that they have to pay to get started, are they really going to do that? Well, from just an economic standpoint, it would not make sense. Sometimes they'll do it anyway, just to kind of send a message to say, hey, look, don't try and compel arbitration and think we're just going to go away. Okay. So it certainly is a strategy. Now, if they don't show up in arbitration, it'd be the same as in court. They'll end up losing that case. And then that can be very beneficial when it comes to, credit reporting and things of that nature. And let's see here. Looks like Miro Williams says, hello, everyone. So hello, thank you for joining us here. And just let me know if you have any questions or comments, and we can definitely try to answer those. So just, going back to the arbitration, if you're being sued, it can be a strategy. You really need to know how good is the court that you've been sued in? What do the judges do? What are the rules where you are? And then see, does it make sense to force the other side into arbitration? And look, it's the same thing, but kind of reversed. When we sue debt collectors or we sue Capital One or Synchrony Bank or whoever it is, they have to decide if the arbitration agreement gives them permission to arbitrate, do they force us to arbitrate? And sometimes they do. Sometimes they say, hey, John, you've got to go to arbitration. And then we may argue about, or we go into what's called JAMS, JAMS, or we go into AAA, which is American Arbitration Association. And, we'll go back and forth and who's paying what. And then we may agree to it, or we may say, no, we're going to fight you on this. But same thing, whoever is being sued can decide, do I want to force this into arbitration? And whoever's doing the suing, if the arbitration agreement allows it, you can certainly push to file that directly in arbitration. Typically, it's faster. Typically, the rules of evidence are, I think how to say this, are just sort of more open, okay? Because arbitrators, about the only way they can be reversed by a judge is just not considering evidence. There's really no appeal based on, well, I think the arbitrator reached the wrong conclusion. Judges aren't interested in reviewing arbitrators for that. But if they just say, I'm not going to hear any evidence on something, that gives an opportunity to maybe get them reversed. So most arbitrators are pretty free in terms of like, hey, bring in all the evidence you want, and then I'll evaluate it. I'll give it the weight that it deserves. Okay. So it's a little bit sort of looser rules than being, for example, in federal court or even in state court. And that can be to your advantage or maybe to your disadvantage. So just keep that in mind. Arbitration, we do arbitrations. Obviously, we do court cases. And one thing with COVID, it's just really slowed down jury trials. I mean, we had a jury trial we were supposed to be trying in the middle of March of 2020. And that's right when the shutdown happened. And I mean, we're looking probably this in federal court, I don't know, August, September of this year on a case we were supposed to try in March of last year. So, it's slowed down with arbitration. That tends to be a little bit easier. It's typically all done by Zoom. And instead of having 6 jurors or 12 jurors, you have typically one arbitrator. So that makes it a little bit quicker. So just let me know if you have any follow-up questions on arbitration. And let's see here. We have Extreme. Hello. So good to see you, Extreme. Thanks for being here. And then let's see. Jeff says, this is on your credit reports, Jeff. I say, my date open seems to be changing on my accounts. Thought that was when the account was open. Well, the reason you think that, Jeff, is because that's exactly what it means, okay? I will give you sort of one little exception here. But let's just take a Capital One credit card. Okay. So you open that on September 1st, 2016. Well, then on your Equifax and Experian and TransUnion, it should say, September 2016 or whatever I just said 20 seconds ago. And that should not change. Now, if it gets sold to a debt collector, they will put in an open date, which is not the date that you open the account. That open date actually means when did the collector get it? So they might get it in 2018 and wait 6 months and then start reporting it. Well, it would not be the date they report. It would be the date that they actually received the account. So if you have something different than that, in other words, if it still says Capital One, but maybe the three bureaus have different open dates, something's wrong with that. It could be Capital One, the furnisher is messing up. It could be Equifax's, Experian, or TransUnion. But the open date should be consistent across all of your credit reports for that account. And if it's not, then that's a great reason to dispute it directly with the credit bureaus and say, hey guys, there's only one open date. There is a date that I opened this Equifax. Why do you say September 2016 and Experian, you say October 2016? It needs to be one or the other. So Jeff, let me know if you have any other questions about that, and I'll be glad to answer those. Let's see. And Muriel says, good question, Jeff. That really is a good question. And let's see. Extreme says, Credence Collection Agency was reporting my account weekly to FCRA for like a month. Is this legal? So I'm not familiar with this collection account, but any debt collector or really any creditor, they're all called furnishers because they furnish information to the credit bureaus. They can report as often as they want. It just needs to be once per month at least, but they could update every week. Okay. So just the fact that they are updating every week does not mean that, there's any problem with it. And I'll tell you one kind of advantage of that when you do have these companies that update very often is if you dispute it, and disputing it directly with the debt collector can be by phone, it can be by letter, it can be by email, but you want to be able to prove that you actually disputed it. And when you do that, and then that debt collector updates your credit report, they have to mark it as being disputed. It'll say something like consumer disputes. Okay. And so, and this is different than going to the credit bureaus with the dispute. This is directly to the debt collector. So this is not under the FCRA, the Fair Credit Reporting Act. This is under the Fair Debt Collection Practices Act. And when you do that, then when they update, they better mark it as disputed. Well, if you dispute it today and they get it today, and then on Friday they update and they don't mark it as disputed, well, normally they have violated section 1692E8, and that's the FDCPA, section 1692E, which talks about no false representations. And then the example is in parentheses 8, and that says no false credit reporting, including the failure to mark an account as disputed. So when you have these collectors that are really updating quick, it means once you dispute, you don't necessarily have to wait 30 days or 45 days for them to update because they're updating every week. So that can be an advantage. Same thing if you pay them money. And let's say you owe them $500 and they say, pay us $300 and you're settled, you pay them $300. And then for the next 2, 3, 4 weeks, they leave it on your account that you owe $500, or they, take the 500 minus the 3 and they say you owe 200. Well, then that's a problem when they're updating every week because they're supposed to update only accurate, complete information. So that can give you some advantages in terms of going after them. So appreciate that question. Let's see here. Golden Gate says, being sued by an attorney for a personal loan I stopped paying. They're the wrong address, have not served me, but have attempted. The debt is $13,000. Will they drop the lawsuit? So it's a very good question. It certainly depends. There are lawsuits that are dropped because they cannot get you served. I would say at least in Alabama where I practice, that's incredibly rare. The judges tend to be very lenient, giving them a long time. I mean, I've had cases where they will give the debt collector sometimes 5 years to serve somebody. I mean, it's a pretty long time. It's unusual, but I have seen that. So if they don't get you served, then either they will dismiss the case without prejudice, or the court may dismiss it without prejudice for a lack of service. Now, just keep in mind that sometimes if they can't find you, they can do what's called, at least in some states, publication by service, kind of like taking out a newspaper ad. Okay, not that really very many people read a physical newspaper, but it would have a little legal notice in there and say, hey, we filed this suit. We're trying to serve, John Watts' last known address. We're hereby giving notice to the world through this newspaper. And if the judge approves that, then that's considered service. So if they have not served you, then what I would do is just make sure that you're sort of keeping an eye on the court case, because they may do that service by publication. They may hand it to somebody and just either incorrectly, or they may lie and say, oh yeah, we served you. And so then the court thinks you've been served, and kind of the clock's ticking, to answer. And if you don't, then you get a default judgment. So, but to answer your question, will they drop the lawsuit? That certainly is possible for them to do, but not real likely. So I would not count on that, but just keep an eye on that. So I hope that that's helpful to you. All right. So Brian says, I know a person's credit score often decreases a little bit after making last payment on an auto loan, but do the CRAs have to report that account as something beyond just closed? Okay. So very good question. And it may be even kind of two questions there. So your score can decrease after paying off a loan, which is sort of ironic, right? It's like, I have less debt. Why would my score go down? Generally, it's because when we're talking about credit scores, we're normally always talking about FICO, F-I-C-O. And FICO has a number of factors. So they say, what's your payment history, your length of having accounts, is your oldest account like 2 years old, or is it 22 years old? And then they look at, your balance compared to available credit. So if I have a $10,000 credit card and I'm at 1,000, that's pretty good. If I'm at 9,999, they go, hey, you're maxed out, and that'll drop the score. But they also look at your sort of the mix of credit. So do you have some installment loans like a mortgage or an auto loan or a student loan? Do you have credit card debt? Do you have personal loans? And so sometimes when you pay off an installment loan, maybe all you have left are credit card debts. Well, so you have this installment loan, auto loan, and credit card debts. This goes away. And I mean, I've seen people pay off a student loan, never late on it. They pay it off, and their score may drop 30, 35 points on FICO. So it happens. Now, that score will start to go back up, but FICO just likes to see that kind of nice mixture of credit card debt and installment loans. Now, as far as what the CRAs have to do in reporting that, I mean, once it's paid off, it should show up as a zero balance, and then it should be closed. And besides that, there's not a real particular information, unless maybe it was a negative account. And then there's certain things we look for. Is there a date of first delinquency? What does the payment history look like? So if you have any more specific questions on that, just put them in the chat, and I'll kind of take these chats in order, and I'll pop your follow-up back on the screen. But I hope that that's helpful to you. And thanks for that question, Brian. So let's see. Jerry says, nowhere on 3 credit reports does my full name appear, including suffix third. Okay. It's recently updated with open credit. Question 1, can I compel the deletion of all other forms of my name? So in general, yes, because the credit report has to be accurate. And I'll use myself as now I'm just John G. Watts. That's all I am. But let's say I was John G. Watts III. Okay. And they had my name as John G. Watts, John G. Watts Jr., John G. Watts II. Well, I could dispute that and say, hey, that's not me. I'm the third. Okay. I'm not the second, or I'm not a junior. I'm not a senior. I'm the third. Now, part of the difficulty for the credit bureaus is there will be some of these furnishers that furnish or provide information that will only list just your first and last name. Okay. So they may have it recorded in there that like this Capital One account goes with John G. Watts Jr. Okay. And, or just John G. Watts. And so what you would want to do is a couple things. First of all, you want to prove exactly your name. So, here's my birth certificate, here's a tax form, here's my driver's license. And you've got to make sure that you're being consistent in your life with using, in my example, John G. Watts III. Okay. So if my driver's license just says John G. Watts and my tax form says John G. Watts, well, it's kind of hard for me to fuss at the credit bureaus for not using John G. Watts III. Okay. So you want to have some consistency there. And so send that to them. The other thing to keep in mind is if they delete one of those names, that could make one or more of your accounts go away. Now, if they're negative accounts, maybe you don't care, but it could be a positive account if that account is kind of tied with that particular form of the name. Okay. Now, it's unlikely stuff will be deleted just because of that, but you certainly have the right to have accurate credit reports, and that includes your information. So, if your name has changed, you can, request that they delete all other forms of it. And so let's see, there may be a follow-up question here. Okay. Yeah. So Jerry says, and can I compel the deletion of certain old addresses since they are associated with non-full name with suffix there? Well, I'll just say this, not necessarily because they're tied to a certain name, but just if it's not an accurate address. Okay. So let's take a couple of examples. So let's say I live right now at 123 Main Street, and they have on there 789 First Avenue. Okay. Now, I never lived at 789 First Avenue, Birmingham, Alabama. Well, that's easy. I'd say I never lived there. Here's my driver's license, or, here's an affidavit, just have a notary, sign saying that you put this under oath, or just put in the letter, like I just have never lived there. Okay. And so that's one way to do it. If you did live there, and so you don't currently live there, it's a little bit of a gray area. And by that, I mean, it is accurate that you used to live there. But personally, if it's the previous address I was at, I may want to leave that, just because until you get a certain amount of history, usually a couple years at your new address, sometimes they want that previous address. But if we're talking like an address 4 places ago or 4 years ago, then there's nothing wrong with disputing that and saying, hey, I want that address off. But then this is sort of my rule with doing disputes. You say, here's what I want because, or so that, or here's the reason why. And then you give the reason why. So I don't want these old addresses because I don't want any mail or pre-approved cards or anything like that going to that old address where I don't live. Obviously, it's too late for the Postal Service to be forwarding that address. So I don't want to be the victim of identity theft because you have these old addresses on there from 4 years ago or 14 years ago or 44 years ago. And so it's not so much, in my view, that it's tied to the first or the second or the third in terms of your name, but more of just, I don't live there. And if you never lived there, that's easy. If you used to live there, you can say, this is no longer accurate. Okay. I no longer have an address of 789 First Avenue North. Okay. So I hope that that's helpful to you, Jerry. Very good questions. Let me see here. So Golden Gate says, vehicle with Toyota's behind and with COVID, they've been lenient. They lifted the repo hold, but they can't locate the vehicle. The loan is 12 months due. Will they file a replevin or just charge it off? So typically a replevin is a lawsuit to actually go recover, for example, the car. Okay, so they could repo the car, but they can't find the car. They can sue us and then get the court to say, okay, John, you've been sued and I'm entering an order that you must turn over this property. I don't see that very often with just regular cars. Okay. I'm not saying it doesn't happen, because it does. I just don't see it very often. I see it more where, we've got like $100,000 Class A, like the big, sort of look like a bus RV, and somebody hasn't been able to find that, and they want that back. Okay. Because they don't just want to sue you for $100,000. They want the vehicle because it has a lot of value. If it's a vehicle worth $1,000, they're not going to be particularly concerned about getting that vehicle back generally. So the thing with COVID is, you want to find out if they've made you an accommodation. Okay. And that just means under COVID, under the CARES Act, which is the law designed in response to COVID, that they say, hey, you can skip payments, or you can make $1 payment or half payment or 90% payment, whatever it is. And as long as you're within that accommodation, then you should be good, and your credit reporting will stay the same. Now, if you're 12 months behind when you got that accommodation, it's going to report 12 months behind. So if this Toyota is not particularly valuable, then I would expect they would probably just charge it off and then sue you or sell that debt. But if it does have some value, then they may try to actually go get the vehicle. So very good question, and I appreciate you sharing that with us. Let's see. Lance says, this is about Respite law. So that deals with mortgage companies. Is this a venue to ask you a question about the mortgage company failure to make insurance? Yeah, that'll be fine, Lance. So happy to do that. Again, Respite is talking about, there's a whole bunch of stuff, but for our purposes, generally, how are they processing your payments? How are they handling insurance? What if you get behind? Loss mitigation, foreclosure. So Respite federal law is very good for that. And so Lance, definitely ask a question about that. I appreciate it. And let's see, Rita says, if you file a complaint with CFPB about a debt collector not validating your debt, and they send the bill through the CFPB portal and your treatment and diagnosis is disclosed, what do you do? Okay, that's a very interesting question, Rita. So remember, there is power, and Rita brings this up. There is power in submitting a complaint or a dispute with the CFPB, particularly about debt collectors, credit reporting, credit bureaus, places like that. It does get their attention sometimes. And so it sounds like in the bill, this is obviously a medical debt. And what they sent back through the CFPB that then comes back to you has your treatment and diagnosis. So here's the deal. That may be a violation of HIPAA, which is the privacy law for medical bills, medical records. But there's no what we call private right of action for HIPAA, at least not normally, where you can just sue for that. But sometimes there's a way to take that and at least make the debt collector feel very nervous. Like, hey, why were you submitting stuff that has my billing information in it and my personal information? So it's going to depend on, does it just say like X-ray? I don't think the judge is going to get real excited about that. But, if it's like very detailed diagnosis, particularly if it would be something, kind of private or upsetting, then I think that is something that you may be able to go to that collector and say, guys, I think you really messed this up, and either sue them or give them a chance to make it right, drop the debt, get off your credit report, leave you alone, that type of thing. So I would just say, Rita, it depends on the level, so I'm trying to give you an example. If it says went to a doctor for, sore throat or, head cold or something. I don't know that anybody's going to get really excited about that. But, if it's like a cancer diagnosis or, just something more serious, or if it's revealing, test result, which came back positive on blank, well, hey, that's personal and private. You don't want everybody to know that. Certainly not this debt collector to know it. and not to be put into the CFPB portal. So that's what I would say on that, Rita, is just kind of check and see, how much detail did they provide? And then you may want to have a conversation with that debt collector about what they did and why they did it. So very good question. Let's see here. So Cool Breeze says, I have 2 different agencies reporting the same medical bill. Can I do anything about it? So I'm assuming when you say agencies, you mean 2 different collection agencies, not 2 different credit reporting agencies. So the credit reporting agencies would be like Equifax, Experian, TransUnion. And so, we would expect it to be on all 3 of those. But if you have, I'll give you a couple of names. So these are in Alabama, Amsure Debt Collector. So they're collecting this $103, urgent care bill that I have. And then this other collector named Holloway Credit, also in Alabama, they're collecting the same bill. Well, first of all, I don't owe it twice. I only owe it once if I owe it at all. So if they're both collecting at the same time, that would be a problem for both of them. Now, in other words, we might sue both of them, and then it turns out one really had the right to collect and the other didn't, but we don't know which one that is because they're both collecting it at the same time. Now, if they're both reporting it, again, that's a problem. So you have a couple options at that point. You could look at just suing them and saying, hey, obviously one of you guys is lying because you do not have this bill to be reporting on me. Or you might dispute it through the credit bureaus. Now, one thing to look out for is, let's say that Amsure debt collector number 1 is reporting that I owe $103. And they last updated, so I'm doing this on, what's today? January I don't even know what day it is, 10th or something. But let's say it's being reported last updated June 2020. And then Holloway Credit comes in and they're reporting it January 2021. Well, then that would seem to indicate Holloway is the one that actually has this. Amsure had it, and then it got taken away from them, but they left the credit reporting, or they parked the credit reporting. And that's a problem when they do that. Now, it's usually very easy to get removed. If you dispute it with the credit bureaus, they should take it off. The little bit harder question is, can you sue Amsure for that without sort of doing any other step? And that's hard because some judges say, well, hey, June 2020, they did have this account. And so that is accurate, and they haven't updated since. So there's no harm. I think that's wrong, but I can tell you a lot of judges think that way. So I would probably dispute that with the credit bureaus and just say, hey, these both can't be right. These are unreliable companies. Look at all the complaints and the CFPB and Better Business Bureau and lawsuits against them. Don't trust them, and see if you can't get rid of both of them. So very good question, and I hope that that's helpful to you. All right, so Muriel says, I updated my address, but the incorrect address still reports as previous, which I never lived at. Well, so I would, dispute that. And if you've already disputed it, then, look and see how precise were you. What some people will do is they'll say, this is the only address that's correct. Get rid of all the others. And that's one way to do it. But particularly when there's a wrong address, say the 123 Jones Avenue, I never lived there. That is not my address. Get that off. I would be pretty specific, pretty emphatic about it and say, I do not want this false information on there. I do not want mail going there. I don't want somebody thinking I used to live there. Okay. And, if they don't correct it, they being the credit bureaus, you can ultimately sue them. Now, generally, we would have something else to sue them for besides the address, but it certainly would be legitimate if they refuse to remove that. And I will tell you this, disputing addresses, a lot of the online portals, they make it challenging to do that. I want to say, I don't use online portals very often, but maybe TransUnion you cannot dispute, or Experian you can't dispute at one of those. I would just do a letter, like a good old-fashioned letter. It goes in the mail to them, certified mail. I never lived at this address. Get rid of it. And if you're not going to get rid of it, explain to me why. And don't send me a form letter. I want a human being to take the time to explain to me, why are you keeping, 1234 Jones Avenue? Yeah, they will never give you a personalized letter. Okay. But I would still demand it because it's outrageous to me that they will only give you form letters. I think it's kind of insulting. So that's the approach I would take. Let's see here. So, Lance says we've had a mortgage with Freedom Mortgage. They are the worst. Yes, they are, I think. For 4 years, never missing a payment or a day late. Escrow surplus at $20,000. They didn't pay our premium. Okay, let me see. I think there's some more of this here. We've been uninsured for 14 months. Never knew. This week we experienced a $100,000 loss due to water pipe freeze. Should I allow Freedom to pay the cost or sue them? So I would say this: if their responsibility was to pay the insurance, in other words, sometimes they give us a choice. Do you want your mortgage where you pay taxes and insurance separate, or they'll say, and this is the normal, you don't have a choice. We, the mortgage company, must pay that. Then they should have paid that, and now you've had this big loss. I would certainly ask Freedom, what are they going to do? Okay. And you can use Respite to do that, a request for information and a notice of error letter. And those are kind of under the category, what used to be called a qualified written request. And we used to just call it that. Now it's kind of broken into a request for information is literally, hey guys, give me information. Like, why did you not pay my insurance? Why did you not notify me when my insurance lapsed? All these types of questions. What are you going to do about this $100,000 loss? And they've got to respond to that. Now they have a pretty good amount of time, about 6 weeks to do it. But you can also do a notice of error, which, like the name suggests, you're notifying them, hey guys, here's an error. I want you to fix it. Now, if they fix it, they're good. Okay. And the notice of error might be, you let my insurance lapse. I want you to fix it, be responsible for all the charges, make sure everything is put back just like it would have been had I had insurance. And then you can see their reaction. Lance, I would definitely get with a lawyer that deals with mortgage companies and really credit reports too, because, generally what happens is at some point your credit report will get messed up with this. But get with a lawyer that does this type of work to see, when they look at all the details, is this something to sue, like a breach of contract? Is it better to sue? Is it better to give them a chance to fix it under RESPA? There are different possibilities, but that's definitely a very difficult situation for you guys to be in. I'm sorry you're dealing with that. And let me know how that turns out for you. And if you need any help, finding a lawyer, just let me know. Let me know where you live and that type of thing. And I'll see if I know somebody. Let's see. So we have Mike who says, my attorney responded to a complaint within the allotted time frame. And now the attorney for the plaintiff has filed a motion for default judgment stating I did not respond. How is that possible? Well, Mike, that's a fantastic question because it should not be possible. Okay. I'm assuming your attorney filed the answer in court, and then most places they're supposed to serve a copy of that on the other side. And now the other side, if it's not done electronically, so I'll tell you this, in Alabama, I think I've said this before, there's like two things in the nation that we're like, the best at, or, right there at the top. Everything else, we're like number 49 or 50. Okay. Number one is college football. And I say that as an Auburn fan, and, Alabama, in the national championship game. But, we're really good at college football, and our court system, the online court system, is, to my knowledge, better than anywhere else. I mean, I'll see lawyers at conferences and they're from other states, and, I'll say something about what we do. They're like, you can do that? And I'm like, yeah, we've been doing that since like 2008. So everything's electronic here. We file something with court, it automatically sends a copy to the other side. But, you may not be in Alabama, maybe your lawyer had to mail it. Well, if it wasn't received, that lawyer should have consulted the court file to see, hey, was an answer filed? So what I've done in those situations is I file a response and say, it's kind of puzzling because here's my answer. And, you have the stamp file date. So again, we do it all electronically. So as soon as we file it, we get that back. But if it's filed sort of the old-fashioned way, almost everybody I know, you would then have the court send you back one that's called a stamp file copy. And so it'd have a little stamp up at the top. This was filed on this date and time. And you include that with your response to a summary judgment. Like, I don't know what they're doing here. And usually they just, boom, immediately withdraw it. They're like, I'm sorry, we missed it. And sometimes if I, know the lawyer, I'll just email them. I'm like, what are you doing? And, they'll say, oh, sorry, John. One thing to remember, I don't know if yours is a collection case, but the firms that do collection cases might file. So I'll give you an example. We might file, say, 100 cases a year, 100 lawsuits a year. Well, a collection firm might file 3,000, 4,000, 5,000 a month. Okay. It's just a massive number of cases. And so they try to automate everything. Well, maybe somebody forgot to click the button that says there's been an answer filed. And so it just spits out a default judgment automatically. So look, if your lawyer responded, filed the answer, you'll be in good shape, and your lawyer, will be able to handle that. And I expect you'll get a pretty quick apology on that. So let's see here. I was trying to look at the next comment and I scrolled too far. Okay. So Brian says, thank you for a thorough, clear answer. Well, you're very welcome, Brian. I was wondering if the credit bureau had to report that in addition to the account being closed, it's closed and paid in. Oh, okay. Yes, you're right, Brian. I did not say that part, but you're absolutely right. So it should say either it's an open account or it's a closed account. And then there should be a pay status. Okay. Now, when you're currently paying, it'll say, paid per agreement, or if you're 30 days late, it'll say 30 days late. But once the account's closed, that pay status should reflect that, hey, this has been paid. Now, if it was settled for less than full amount, it might say, it sounds sort of weird, but it'll say settled in full for less than full balance. It just means you're settled, no doubt about that. You just didn't pay the whole amount. But let's say you were never late, and just paid that thing off, then yeah, it should just say, paid per agreement or paid in accordance with agreement. And so, yes, a very good point, Brian. I appreciate you following up on that. And let's see, take from your answer. Yeah. So again, they do need to show it as closed, but then it needs to be accurate, whatever they're saying. So remember this with credit reporting. It has to be accurate. Okay. And it has to be complete. Now, accurate means truthful. So if it's false, well, then that's inaccurate. If it's true, but yet misleading, then that can be considered inaccurate, even though it's true. Okay. So I'm trying to think of an example. Brian, I'm supposed to, come work on your air conditioner, and you say, John, you're supposed to be here yesterday and you never showed up. And I say, yes, I did. And what I mean is I drove up to your house. I put like my pinky toe on your driveway at 11:59 p.m. and then I left. Well, is it true that I showed up? Yeah, but it's deceptive, not giving you the full story. So we have accuracy and then we have completeness. So when they don't put the complete information in, again, that can be misleading. And it's just inaccurate. So if you have any specific questions or you want me to see exactly what that is, just, you can get in touch with me through my website, alabamaconsumer.com. So appreciate those questions, Brian. Let's see. Ace Williams, can an account be closed or charged off for 4 years, 2017, now reporting open, late and past due payments every month? I've not spoken a word to them. We're never made an agreement. What should I do? Okay. So, Ace, you can let me know if I'm not understanding your question right. But I think what's happened is that maybe in 2017, stopped paying on it. We haven't made any payments since then. It was closed. It was charged off. And now they've changed it to open, and they're putting past due payments every month. So if an account is charged off, they can report every single month that that's charged off. Okay. But if it's charged off, it should not be reporting as, for example, 120 days late. And it's sort of an interesting thing where we might say, well, it's reporting as 120 days late every month, and I want it to report as charge-off. Well, a charge-off is more delinquent than 120 days. So why would I want that? And I asked that question to somebody in the mortgage world, and they said, because a charge-off, we can get you approved for a loan after a certain period of time. But if you're currently reporting 120 days late, there is no getting you a mortgage loan, like if this is on your mortgage. So sometimes we just need the furniture and the bureau to fix that, to say, no, I'm not 120 days late. This thing was charged off like 4 years ago. And so, we dispute that. We look at every single field. When I say field, I mean just little section on the credit report. So the date open, the date closed, the date of last activity, what's the payment history for, January 2021, December 2020, November 2020. We look at every single detail of the report, and we compare all these reports. So we look at Equifax and Experian and TransUnion, sort of lay them all out. I tend to put them on a spreadsheet. Okay, so literally just like copying and pasting data into the spreadsheet. And then you can look at that spreadsheet and say, like, here's a column for open date. It's like, well, wait a minute, why is it different? Or here's a column for, date of last payment. And that's different among the bureaus. So every possible error you want to point out to them and identify and explain, I want this fixed or I want the account deleted. So I hope that that's helpful. And Ace, if I misunderstood your question, just let me know on that. So Chuck says, Midland Credit Management sued me claiming I owe the debt, but the only thing they attached to the complaints last 2 months of credit card statements. Should I include lack of standing as defense or wait until the pretrial conference to bring up these issues? Okay, so very good question, Chuck, on that. And so some of this is going to depend on where you are. Okay, so I defend lots of people sued by Midland, and I do that in the state of Alabama. And in Alabama, they do not have to really provide anything. I mean, they can just file the suit and say, and they literally used to do this, and just would say, Midland Funding is suing John Watts for a debt he owes. Like, no details. Is it a credit card debt, a car loan? What's the account? Like, they wouldn't put anything. It was terrible. Now they usually identify it's this credit card account, and they'll put a couple of statements on there. Well, in terms of what you do, again, that's going to depend on your state. I'll tell you what we do in Alabama is we would deny owing that debt to Midland. We would deny that Midland owns the debt. And we would put Midland's not the proper party to bring the suit. And just sort of say it in plain English, Midland does not own the debt. And then we would see, what do they do? So if it's small claims or district court in Alabama, which that's typically under 20,000, then, you file your answer, and 4 or 5 weeks later, you're standing in trial. Okay. Now with circuit court, which there's some overlap in our courts. Circuit court's where we have our juries, and then below is district and small claims, but these amounts overlap. So sometimes they have a choice. So they file in circuit court or district court. Circuit court, it might be a year before you're at trial. They may file what's called summary judgment. And so you have to sort of understand the lay of the land in your particular state. Like I said, in Alabama, we would just answer that and then see what they do. Because ultimately, whether they're trying to get summary judgment, which is just telling the judge, no need to have a trial, just summarily enter judgment, or they're going to trial, they still have to prove their case. They still have to prove they own it. And so we can point out that defect. I usually don't push them hard to produce that, because it's obvious that they have to produce the purchase agreement to show that they really own this debt. I mean, it's like, me and my personal injury cases, the defendant doesn't say, well, if John doesn't prove that his guy was actually in the wreck, what am I going to do? No, you win if I don't prove my guy was in the wreck. Okay. So, there's just certain things that the plaintiff, the one bringing the suit, has to prove. And I think showing that they own the debt is certainly one of those. And two statements, what does that prove? It proves they've got two statements. I think the statement should be from zero, whenever you were last at zero, to the last balance. And they should have a statement showing that, because when they just produce the last two statements, the second statement probably says you owe like $4,673. Well, how do we know you owe that? We really need to see those previous statements. So that's the approach that I would take, and definitely get with a lawyer in your state. Even if you're, thinking you're going to do it on your own, just check with a lawyer to see kind of what do the judges want in your state and how does that work. Let's see. Jerry says, thank you. You're very welcome. Thanks for the great question. And Ace says that was Capital One. Okay. And then Mario says subrogation. How does that work in debt collection? I assume that's what you're asking. So subrogation is typically when I'll give you the example that comes up with us. So I'm in a car wreck. Blue Cross Blue Shield, my insurance company, pays $10,000. And then I sue the person that hurt me and I get a settlement. Well, Blue Cross is standing there with their hand out saying, we want our money back. Now, $10,000 worth of medical bills, they probably paid like $4,000. Okay. So they say, hey, I want my $4,000 back. We negotiate on that. Sometimes subrogation comes up. Maybe we are at fault and we damage somebody's car. We don't have insurance. Their insurance fixes the car. Then they turn it over to collection agency to subrogate against us. Typically that subrogation, that debt collector doing the subrogation does not fall within the FDCPA, the Fair Debt Collection Practices Act, because it's not considered a, for lack of a better word, a voluntary transaction. If I go buy food at a restaurant or movie tickets or a couch or something, I've made that choice. But if it's like criminal stuff or tort where I've hurt somebody, then that's not counted. And you might say, well, what about medical, emergency medical? Well, that's considered voluntary. It's just sort of a legal fiction. It's like you had implied consent to be treated for this. So if you have more questions about that, just let me know. Let's see, Extreme. From previous question, there's no dispute notes on my credit reports. Also, dates of activity keep changing, but there's no actual activity on the account. So two things about that. One, if it's a debt collector and you disputed directly to that debt collector, and then that debt collector updates after your dispute, it should show disputed, or you can look at suing under Section 1692E8 for failure to mark it as disputed. Now, if it's just like an original creditor and you've disputed that with the bureaus and it's not marked as disputed, then you definitely need to look at that because that may be a claim. I'm trying to remember if I've done this case or not. It's called the Saunders case versus BB&T. It's maybe 10 years ago from trying to think which circuit it is, maybe the Fourth Circuit. I think it's out of Virginia. And that's sort of the most famous case of not marking an account as disputed. Okay? And so I'll try to check on that. If I haven't done that, I'll do that case opinion because it's a very powerful law. And the reason these companies often don't mark stuff as disputed is it oftentimes will not have much impact on your credit score if it's marked as disputed. Now, you may not can get a mortgage loan if you have a disputed notation, okay? But it typically will remove that negative thing, which tends to increase your score. So when I say remove it, I mean remove it from the scoring model. So if they are not marking it as disputed and you have a legitimate, what courts call a good faith dispute under the Fair Credit Reporting Act, then they should have to be reporting that. And if they're not, potentially you can file a lawsuit on that. So definitely check that out, see what your dispute was. Make sure you're pulling the actual credit reports from Equifax, Experian, TransUnion. Get it through annualcreditreport.com is the easiest place to get that. Through April, you can get it once a week there. So let me know if you have any questions about that. Let's see here. Divine Brilliance, extensions on credit invoked by Credit Protection Act denied due to FICO score, consumer right to credit. So I'll need a little more context on that. If your question is, can you be denied credit because of your FICO score? The answer is yes. Now, whoever denies you credit needs to give you what's called an adverse action notice. So it'll just be, trying to find something that doesn't have writing on it here. Here's a HOA invoice. I'll use that. But you should get a letter in the mail or an email that says, hey, we have taken this adverse action. We've turned you down for credit. And it'll give you some reasons and then tell you which bureaus they use. And then you can get free reports from those bureaus. So I'm afraid, though, I may be missing your question. So feel free to put some more information in, and I'll come back to that. So Rita says, thank you. You're very welcome, Rita. Thanks for being on here. And Ace says, should a closed charge-off account continue to increase the balance monthly? And then the CRAs continue to respond to factual disputes as verified. Okay, so let's go back to this first one. Generally, well, I'll say this. It depends on should the balance increase. A lot of times it does increase because the charge-off is really just an accounting function that says, hey, we're not expecting to be able to collect on this. And so a lot of times you will see that increase. Sometimes you don't. It can depend on the type of account it is. Is it a credit card account? Is it a car loan? What type of account? What does your contract say? And then what does your state law say about that? But I would say most of these will continue to report an increased balance. Now, if it's actually been closed, then that would be a little bit more unusual. Why, if it's closed, is a balance increasing on your credit report? Because if it's a closed account, there's really no reason under what's called Metro 2, which is the industry guideline, to continue to report that every month if it's been closed. So like I have a mortgage loan, I took it out, I sold my house, paid off the loan. That doesn't update every month. I mean, there's no reason to, because that happened in 2014 or 2017 or whenever, and there's no more loan at that point. So it should not keep increasing if it's closed, unless there's just something unusual going on. So I would definitely look at that. And you say you're doing factual disputes. And just so we're on the same page, typically when people say factual disputes, they're talking about they are looking very specifically at the credit bureaus, at the credit reports, and finding discrepancies, finding missing information. This is opposed to kind of this, I think it's a very lazy way of disputing stuff where you just say, please verify all negative accounts. What does that mean? There's no pressure on the credit bureaus for that. Okay. But factual disputes, you're like, hey, Equifax, you say this, that I was 30 days late in June. Experian, you say I was 60 days late in June. Well, which one is it? Can't be both. Or I had one where Equifax had 3 different close dates for the same account. And those 3 did not match, the one from TransUnion and the one from Experian. So I'm like, guys, how many close dates are there? There's only one close date. I can't have 5 different close dates. So correct this, make it 100% accurate, or delete the account. So when they verify those and you've done a good job of disputing, and you can prove that they received the dispute and exactly what you disputed, then I would say that's the point that you sit down with the lawyer to see, okay, is this really something that's wrong, an error? Okay. And if it is, did I give them enough information? Did they violate the law by not fixing it and instead deleting it? Can we sue, or do we need to do another dispute? And I just want to stress this one point. I think I did a recent video on this. I know I've done a number of videos on this. There has to be an actual error. Okay. There's a misconception, and frankly, it's justified by reading the FCRA, but it's not the way the courts interpret it. So in their mind, this is a misconception to think that you can just dispute negative things and say, hey, Bureau, you must go verify this. And if you can't verify it, delete it. But that's not the way the courts interpret this. The courts say there has to be an error. If there's no error, and an error can be it's inaccurate or it's incomplete. If if that doesn't exist, then they really don't have to respond to your dispute. So they could refuse to respond, or they could just verify. And you say, but they did a lousy investigation. And Ace, I'm not saying, you're saying that, just your question brought this up. Well, they may do a lousy investigation, but the judge is going to say, look, I don't care about any of that. I want to know, was there an inaccuracy, an error, an incompleteness to this account? If the answer to that's no, you lose. Okay. If the answer to that's yes, then the next question is, did you dispute that specific error? Okay. So sometimes people say, well, there were 10 errors on this account. I say, well, did you dispute? Oh, yeah, I disputed it. Beautiful dispute. So, okay, let me see your beautiful dispute. They dispute one item, and that item gets fixed. And they're like, yeah, but there are these 10 other errors. I'm like, but you didn't tell the credit bureau. And the response is, well, they should have figured it out. No, that's not what the judges say. The judges say, you have to tell the credit bureau, here's the problem. Boom, 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 boom. Very specific. And then if they don't fix that and they do it in a negligent or reckless manner, then you sue under the Fair Credit Reporting Act. So hope that helps you there, Ace. And let's see. So I guess Untrell Sharp, hope I'm saying your name right there. Good afternoon. Have you heard about the Texas Senate Bill 1037 about credit bureaus reporting medical debt? I may have. I'm not sure. There have been a number of bills about medical debt, and I'm trying to remember if the latest, whatever the bill is called, latest stimulus package that they passed maybe a week or so ago. I want to say that has something about medical debt, and I haven't focused on it, so I just don't know. Specifically, I do not know about Texas Senate Bill 1037. So, if you've got some information on that, feel free to send it to me, or I'll look it up. And but I'm just not familiar with that. But appreciate you asking. Let's see. Okay, so this was apparently not being able to report medical. Okay, well, I will say this: either through bills or through settlements, typically medical debt is not going to be reported before 6 months. And sometimes that's 6 months after denial of insurance. Sometimes it's just 6 months. But the idea is you're not supposed to go to the ER today and then tomorrow you wake up and you've got, $27,000 on your credit report. They're supposed to give you time to pay this. And so there have definitely been pushes made to not allow medical debt to be reported. Even FICO, the scoring model company, some of their newer models really downplay or even ignore medical debt that is paid, or even that's been put on within a certain period of time, because I think everybody recognizes it's just a disaster out there with medical debt. I mean, you go to the ER, you see a nurse, you see a doctor, and you're like, okay, and you pay your copay, and you get a bill from the doctor group, because that's separate from the hospital. Like, okay, I guess that makes sense. So you pay the doctor. And then like 3 years later, you get a bill from the anesthesiologist. You're like, I didn't see an anesthesiologist. They're like, well, you went in this room and an anesthesiologist thought about you. So that's $3,000. And we waited too long to bill it on Blue Cross. And so you're going to have to pay it, or we'll put it on your credit. Everybody has had, and obviously I'm exaggerating, but everybody's had that type of experience. So, judges understand that for the most part, the scoring models do. And generally, if you're disputing medical debt, that will come off, because they know it's just so unreliable that they often realize that there are mistakes made with it. So, but keep us posted if that bill passes. I'd be very curious about that. So Cool Breeze says, thanks, very helpful. You're very welcome. And let's see here. Well, I think, okay, here it is. I lost my place here. Okay. Muriel, thank you for sharing knowledge. Again, you're very welcome for that. So ComTube says, can I opt out of Chapter 13 while still in the middle of Bankruptcy 13, later after deal with the actual creditors and third-party creditors myself once I forfeit? Okay, so I think I understand the question. So you file a 13, and you're in that world of 13. Can you get out of it? Typically you can. Okay. Now, there, I guess, could be a reason why a judge wouldn't allow you, but generally if you have your lawyer go to the trustee or the judge, however your district does it, and say, hey, we want to dismiss this chapter 13, so dismiss it. And while you're in the 13, you have this protection of what's called the automatic stay. It's like a force field around you that says basically, without permission from court, no lawsuits against you, no repos, no foreclosures, no sort of aggressive action like that. And frankly, even sort of more minor, like they can't be calling you, saying, hey, you better pay this bill. When you leave chapter 13, then it's like that sort of force field around you just goes away. Okay, now you're just like a normal person, okay, that they can call you, write you, sue you, repo, foreclose, whatever. So, but yes, there are people that will get out of a 13 and then deal directly with their creditors or collectors. So that should definitely be an option. I would just talk to your bankruptcy attorney about that. And that ought to be, relatively easy to do. I mean, generally the problem is people are getting kicked out of a 13 for not making payments. And, they're like hanging on by their fingernails to stay in it. But if you say you want to be out, then I think most judges would gladly let you out. And so a good question there. Let's see. Jeff says, if you have a collection charged off, should it still say open account or have a past due balance? So it kind of depends. If we're talking about just like a true collection account by a debt collector, it wouldn't normally list a past due amount, although I see that sometimes with like Midland or LVNV. It should just say, hey, this is a collection account. Typically, it will report as open, and then it'll have the balance. Now, if it's charged off and is still with the creditor, it can say open account because charge off is, again, an accounting function, okay? And so it's just under accounting rules, generally accepted accounting principles. There comes a certain point where you have to mark it as charged off. But it doesn't mean that they've given up on collecting. It's just they think it's going to be hard to collect. So it could still say open, but that's one thing I would check all three bureaus. And look, I use Smart Credit sometimes for my clients because it's necessary, or Identity IQ, I think is the other name. All those monitoring services, they're great in their own way, but it ain't the real thing, okay? I mean, what they say Equifax says is not necessarily what Equifax says. So really go pull Equifax, Experian, TransUnion, pull your actual credit reports. And I would just compare very closely, because what you might find is that one will say open and one will say close. And one will have a payment history for this month and TransUnion won't over here. And that gives you a great basis to start disputing stuff. So very good question, Jeff. So let's see here. CD says, Velocity is trying to sue me. I filed an answer because original contract had binding arbitration. Okay, that's great. That's what we mentioned when we opened this video. After that, they sent paperwork that the judgment is against me and to sign a payment agreement. But I called the court. They said there's been no judgment. How can I sue them for basically lying? Okay. It could be that. Okay. So let me back up here. So you file an answer saying that they have to arbitrate. Well, until the judge orders them to arbitrate, you're still in court. Okay. So if they say that there's a judgment against you and there's not, then that's a big problem for them, because Velocity is a debt collector, a debt buyer based out of New Jersey. And the collection law firm that's doing that is a debt collector. Okay. And so if they sent you a letter saying, we have a judgment against you, you need to start making payments, here's a payment form, or here's, put your credit card or cancel check or whatever, that's a big problem for them because that's a lie. Okay. Now, what they probably did is sent you what's called a consent judgment. Okay, at least that's what they do around here. And that says, hey, just sign here and you'll agree to a $5,000 consent judgment, and we'll take $200 a month and we won't garnish you or put a lien on your property as long as you make the payment. So I would just look and see which one it is. If it's that consent judgment, I think it's kind of in poor taste, but you can just kind of ignore it and, ask the court to compel arbitration. But if they told you there's a judgment and there's no judgment, then I'd be talking to a lawyer. I mean, I'd talk to one anyway, but definitely be asking the lawyer, hey, can we file suit on this? Because that's a lie under the FDCPA, Fair Debt Collection Practices Act. And that's at section 1692E. And it gives you all these examples of what are lies. Okay, so I would definitely check that out. And let's see, Lance sent you an email. Okay, well, I'll check out that email, Lance, and thank you for the kind words and being on here. I appreciate it. And let's see, next comment, Brian, thank you so much. You're very welcome, Brian. And let's see, Muriel hit the like button. Well, thank you. I'll say this, I've never, maybe I just don't know how to do YouTube the right way, but I'll watch videos and the person doing the video will, like 4 times in the video, talk about smash that like button, that notification. I don't know. It just seems kind of cheesy to me. Of course, they have 10 million subscribers and I have, 14,000 or something. But I figure if you like the video or want to get more content, you'll hit like. And so I appreciate you doing that, or subscribe. Let's see here. And let me check the time. I've got about 15 or 20 minutes here. I'll try to wrap up the questions we have. So Rita says, do all CRAs report a status of paid when it is charged off, or can they write paid it in the comments? So when an account is charged off and then it's paid, the status should reflect paid. Now it might say paid account, previous charge off, or paid charge off. In other words, kind of giving the indication this was charged off, now it's been paid. Okay, but it definitely needs to say paid in there. So I'll give you an example, and this generally is not on credit card debt. It's more of auto loans and mortgage loans. But let's say that you were 90 days late, and sometimes student loans. So you're 90 days late, and it says pay status 90 days late, and then you pay it off. Okay, you sell your house, you trade in the car, or you literally write a check, pay it off. And so there's a zero balance. There's nothing more owed on this. Several of the bureaus will leave the status as 90 days late. And they'll have updated that after you paid it off. That's wrong. Okay, that's just absolutely wrong. And if you have that situation, reach out to me, alabamaconsumer.com. I'd like to see that, because we're bringing these suits, and first of all, I can talk to you about, do you have a claim? But also, just the more that we can show judges, this is not an isolated thing, but it's this person over here and here and here and here, all these different people suffering from this, then it makes each case more powerful. So we call those status cases, and just be looking for something that says like 90 days late, 120 days late in the status, and you paid it off. Because that is not the current status. The current status is paid. Okay, it's not 90 days late if you have paid it. Because if you paid it, you can't be 90 days late, right? There's nothing to be late for. Now, I'm not talking about the history. Okay, so if I was 90 days late, 90 days late, 90 days late, boom, I pay it off. They can leave that past history, but the current status better say paid off. And again, it could even say charged off if it was charged off, but it needs to say paid. So great question there, Rita. Let's see. Mario says, thanks. You're very welcome, Mario. And Extreme, thank you very much. I'm in Colorado, but I'll contact you, look at my situation, see if you can assist. So you're very welcome. And yeah, just reach out to me. And it may be something where I say, hey, this one lawyer in Colorado, that's who I think you ought to go to. Or I may say, I don't know anybody in Colorado, but it may be we can bring the suit to another case. So I'll give you an example. We may have a case against Wells Fargo, and they're based out of California. And we may say, you know what, let's sue them in California. And then I just work with a lawyer that I do some cases with in California. He files a case, gets me admitted to California for that case. So sometimes we choose where to file the case based on where the defendant is. Often it's where the plaintiff is, but particularly in this sort of COVID world, it's not like you're going to be flying somewhere anyway right now to go to trial. And again, a lot of this ends up in arbitration, and that's all done by Zoom anyway. So, it doesn't really matter. And sometimes it's more advantageous to be in this particular location or that location. So definitely reach out. And CD says, I'm in Georgia. Hey, that's right next door. And I've got, a very close friend. We work on a whole bunch of cases in Georgia together, and he helps me in cases in Alabama. We kind of get each other in on cases because we have different sort of expertise. So definitely reach out, and that might be a situation where I say, hey, go call this guy and he can help you. Let's see. Heather says, mortgage company filed complaint for default after I notified them they had the wrong balance amount. Judge denied their motion for summary judgment. They filed second complaint with true balance, still reporting wrong amount. Okay. So I'm not sure if this is related to a foreclosure or they're just suing you for the amount. So the judge denied their summary judgment. That's good. When you say they filed a second complaint, I don't know if you mean a separate lawsuit or an amended complaint. Sometimes they'll call it like first amended complaint, second amended complaint, but all within the same lawsuit. Okay. So if they filed it with the true balance, that's good. But if they're reporting a false balance, now see, that's where, and I know I harp on this in a lot of videos, but when we're sued, we need to be looking at credit reports. Okay. Because you're looking at this different data that's being put out there. So let's say Wells Fargo suing me for $100,000. And then they realize, oh, actually, I only owe them $75,000. So they amend their complaint, say, we're sorry, we've got the correct amount now. It's $75,000. But on my credit report, they say, oh, $100,000. Well, see, that's a fantastic dispute to make to the credit bureaus and say, they know this is false. I told them it's false. And look at their most recent lawsuit against me. It's a totally different number. This is the real number, not what they have on my credit report. And see if they fix it. If they don't fix it, now you've got potentially a Fair Credit Reporting Act lawsuit case against them. And, there's a few states that have some state laws, like California has a state law that you can bring also against them for that. So definitely that's something to look at. If you don't have a lawyer, I mean, obviously if you have a lawyer, Heather, talk with that lawyer. But if you don't, then get with the lawyer. If you have a question about maybe who to talk to in your area, feel free to reach out to me at alabamaconsumer.com, and I'll see if I can get you to the right person. And but I think that should be disputed. And if they don't fix it, then I think you need to go after them for that. So great question. Let's see. The Victor says, if I see an error on my credit report, should I dispute based on 1681 EB or 1681I? That's a fantastic question, Victor. So those are two separate sort of avenues to go after the credit bureaus. So the EB claim is what's called maximum possible accuracy. So they have to have reasonable procedures to assure maximum reasonable possible. Let me say that again. Reasonable maximum possible accuracy. You don't have to do a dispute to trigger that liability. It's just the fact that they are compiling this information that's incorrect. Now, in certain places, like where I practice, the 11th Circuit, so that's Alabama, Georgia, Florida is the 11th Circuit, we have to have what's called a credit pull, not by us, the consumer, but by some creditor or potential lender or somebody like that. They have to pull our credit. And so somebody has to see the false information. So it's kind of like defamation, slander, libel. Somebody has to see the false statement. In other words, if for you, Victor, I got this piece of paper and I said, Victor is, wrote all these horrible things about you, never showed it to anybody. That's not defamation. I have to publish that to somebody. Well, some of the courts say for an EB claim, there has to be publication. Others don't. Okay. You just, hey, you find the error, you sue on it. Now, if you dispute it, the mechanism to dispute it is that 1681I. And that triggers an obligation on the credit bureau to, number one, investigate it. Number two, unless they can figure out the answer, to notify the furnisher within 5 business days, or maybe it's just 5 days. I can't remember, but within 5 days. I think it's just 5 actual days. And so the furnisher can now start investigating. And once they do that, now the furnisher has liability if they don't fix it under what's called 1681 S2B. Now, 1681 S2A sounds fantastic, but you can't sue for it. So when the credit bureau notifies the furnisher, now the furnisher has liability if they do a lousy investigation. So now here's where it all kind of merges together. So you do a dispute and Equifax doesn't fix it. Well, then you may sue under 1681I for doing a lousy investigation and sue under 1681EB. You're like, guys, you don't have reasonable procedures. And I told you this was wrong. And you still didn't get reasonable procedure. You still messed it up. So you often will have both claims. I'd say 90% of our claims that we file, we have EB and I claims. So great question. And let's see here. Jerry says, is it appropriate to show Credit Bureau 1, the other credit bureaus, print out a strategy to request Credit Bureau 1 to fix, delete an account? How should a letter read? Yeah. I'll tell you the way that I do it. This is not how everybody does it, but I do it this way. My dispute letter will have Equifax, Experian, TransUnion, Innovis, SageStream, whoever it is. I just list all the credit bureaus I'm disputing, and I just talk to them all at the same time. Now, within there, I may say, on the Capital One account, I may say, now, Equifax, you're reporting the date of first delinquency. Experian and TransUnion, you are not. I want this corrected or deleted. Hey, Equifax, you're reporting this payment history for June 2018, but TransUnion, you have something different. And Experian, you have blank data there, like no data at all. What's going on? So you can either describe it to them, or particularly if you have, PDFs of it, and you can sort of just like take a little snippet of it. Like you could drop in, here's what TransUnion's reporting, hit enter a few times. Here's what Equifax is reporting, hit enter. Here's what Experian's reporting, just so they can all see it. But that's definitely legitimate to do. The other bureaus are not bound by what a different bureau does, but it does put them on notice. And what I was just talking about with Victor about that EB claim, maximum possible accuracy, the more information you give them that should make them question what they're doing, that's helpful. And under that I claim for reasonable investigation, well, let's see what materials they had as they were looking at that. And I just need to check the time here. So just a few more minutes. We'll just go with the remaining questions we have here. If I can get these up. And if I'm missing any, either reach out to me directly, or I will try to save these and then do them on the next live. And I'm going to try and do the lives more often. Just time kind of got away from me, but I enjoy doing these. And if you guys like them, I'll do them. So let's see here. Heather says, going on 4 years, my score has been murdered, went from 720 to 400. Is this FCRA or RESPA or FDCPA? Plaintiff is assignee of private real estate contract, season 15 years. Okay, so private real estate contract is probably not RESPA. And as far as is it FDCPA, that's normally going to depend on, was it in default when the assignee got it, the person that claims to have bought it, was it in default? And are they in that business of collecting debts owed to others or buying defaulted debts? Then they may be a debt collector, but certainly the FCRA. So what I would do, Heather, is just really focus in on the credit reporting on that account. And what I'm about to tell you, I feel confident you'll do it. I'll just tell you, some people won't do it because they're like, well, that sounds like it's going to take more than 5 minutes. Well, yeah, I mean, it just cratered our credit score. So it's worth taking time. But you literally have to take every single piece of information that you can find from Equifax, from Experian, from TransUnion. That means go to annualcreditreport.com, go to myequifax.com, set up an Equifax account. Sometimes the data there is different than annual credit report. It's not supposed to be, but it is. Set up an Experian.com account, get a Credit Karma account, or get a TransUnion account. I'm not aware of a free TransUnion other than kind of Credit Karma. But point is, get all the credit reports you can, and then you're looking for discrepancies. You're looking for things that are not correct, and you dispute it. And I did a recent video on this where, I'll hear people say, well, only dispute 1 or 2 reasons at a time. I just think that's crazy. Like if you've got 24 errors, put them all in there. I mean, if the last 24 months of payment history, every month is wrong, put that in there. If for me, I just don't say, hey, the last 24 months of payment history incorrect, please correct. Because, well, what's wrong with it? Well, spell it out. January, this is what's wrong. February through April, this is what's wrong. May through July, this is what's wrong. So just be very, very detailed. And if that's what's caused your score to go down so much, if you can get rid of that, it may not be an immediate recovery, but removing bad stuff tends to bring our score back up. Now, sometimes our score goes down and then we fall behind because maybe interest rates go up or something like that. And so there may not be as much a recovery, but it's always good, in my view, to get rid of inaccurate information. So I hope that helps. Let's see here. So Jeff says, I have a collection that I never paid in 3 years. Now it's updated as paid for full, or paid for less than full balance, paid charge-off. That's interesting that you haven't paid it and it's reporting that way. I would, if you are looking for, like a mortgage loan or something, or you just have a buddy in the mortgage industry, I might ask them, hey, is this helping me or hurting me? And if it's helping you, it says paid, you may just leave it alone. If it's hurting you, then, you certainly can dispute and say it's not paid. It's just, it kind of puts you in an interesting position of, well, what if they fix it and report it as being unpaid? Is that going to lower your score? So you just have to be aware of the consequences of it. But that's an interesting situation. So Victor said, are the credit bureaus subject to FCRA for online disputes? I'm hearing conflicting. Yes, however you get the dispute to the credit bureau, they are responsible under the FCRA. So you could call it in if they accept calls on disputes. You can fax it if they accept faxes. You can do it online. You can do it by letter. The key is to prove that they got your dispute and exactly what did you say. So I'm not a big fan of online disputes, but if you do them, just, like my screen is being recorded here. Okay. Well, that's not exactly the right way to say it. I could put up part of my screen and then that would be recorded. And that's what I suggest you do with online. So go to loom.com or Snagit, Snaggit, maybe 2 T's. But you can get free trials of their screen recording software. And that way, you log in, you click record. And so you know exactly which account you clicked and here's the document you uploaded and here are the reasons you typed out. Because amazingly, they will lose this information. The credit bureaus will when you sue them. So I prefer certified mail, real letters. There's some advantages. I won't go into all that. But if you do it online, just make sure you can prove what you did, when you did it, and exactly what you said. But yeah, online disputes are real disputes and they have to process those. So great question. So Gene says, hit the like button. Well, thank you very much. I appreciate that. And let me again check my time here. Dan says, hello, I filed a motion to set aside, but the court didn't like it because they're stating I had 30 days filed, but I didn't know anything about it until now. Okay. So there's a couple things here. If it's a default judgment and you were served, I'm telling you under Alabama Rules Civil Procedure, it can be different in another state, then generally you do have 30 days to set it aside. So if you file it beyond that, it's not going to be successful. But at least in Alabama, if you were not served, then there really is no time limit. I mean, once you figure out there's a problem, you need to act quickly. Okay. But I have had people come to me with judgments from 15 years ago and they were never served. And we file a motion to set aside that default judgment and it gets set aside because they weren't served. It's no good. Now, if maybe you're talking about after a judge enters an order or after a trial, you have a certain period of time, to dispute that or request the judge reconsider, set aside. Then if you didn't know about it, it's really going to depend on the law. Most places I know of say it's your responsibility to know what's happening in your court file, sort of as if you're going to call the court every day. Anything happened today? Anything happened today? But that's kind of the way the law is worded. And so we just have to know more about that. But if it's a default judgment and you were not served, I would get with a lawyer in your state. If you're in Alabama, you can get with me. But if you're in another state, get with the lawyer and say, if I wasn't served, can I attack this judgment? And the reason I think you can in basically every state is it's sort of a due process thing. If I wasn't served, I have no way of knowing that I need to defend myself. And so to my knowledge, every place you can attack that judgment. Now, whether you're successful, whether you can prove to the court you weren't served, that's a different matter. But wish you all the best with that. And let's see, Rita says, thank you. You're very welcome, Rita. And Hobby Lobby, do you represent outside your state? So I do not if it is a debt collection lawsuit. I mean, you really have to have somebody in your state. If you need to sue somebody under a federal law, then sometimes I do. I mean, I had a lady from Hawaii that she had been sued, I want to say like in Boston, won her case, thought everything was good, moved to Hawaii, and they put on her credit report that she owed the debt. She's like, I won my case. She disputed with the credit bureaus. They wouldn't fix it. So we sued. And she reached out to me and I said, well, let me get you a lawyer in Hawaii. She goes, no, I want you as my lawyer. I said, well, I got to file your case in Alabama. She goes, okay. And so she agreed to it. So we filed in Alabama. And so, sometimes we do that, or we may sue the defendant where the defendant is located, which might not be your state. So depending on what it is, I can certainly look at it. But if it's being sued by a debt collector, if it's a foreclosure case, you really have to have a local lawyer to do that. Because, I mean, that is literally in your state. And unless it's Alabama, I'm not licensed there. But if it's suing somebody under one of these federal laws, then sometimes we have a choice of where to bring those. And I can bring them in my state, or I may know a lawyer in your state, or there may be another state that we can bring it in. So I'm always open to, if you want to email me and say, I did a video today talking about this. I mean, just lay out exactly what's happened, be very clear, very precise, and then I'll see if I can help you with that. So thank you for asking. So after answer to debt collection lawsuit, received a trial date now, they filed a motion for order deeming admissions 1 month before trial. Do I answer a motion or wait for trial? Okay. So evidently what happened is they served you requests for admissions. That's a discovery request. So we have interrogatories. Those are like interrogation. We have requests for production documents, turn over all these documents. And then we have a request for admissions, which will say admit or deny, that you had a Capital One card ending in 1234. Well, if you don't respond to those within 30 days, then they are deemed admitted. And usually they have really explosive ones in there, like admit you have no defense to this case. Admit that you owe us everything that we claim. Admit you're a horrible person. Okay, they usually don't have that, but that's sort of, they're over the top with it. And so generally the rules say they don't have to sort of ask the court to deem the questions to be admitted. They're just admitted automatically. That's kind of a custom. Lawyers do that. I would definitely respond to that. Did you respond to the discovery in time? If you did, say, hey, here's where I responded. If you did not, I would, obviously get with a lawyer. If you have a lawyer, if you don't have a lawyer, you get a lawyer in your state. But what I do, if somebody comes to me like that in Alabama, is I go ahead and respond to those admissions and then tell the court in writing, say, hey, whatever our reason was to miss the deadline. But look, now we've responded. Please hear the case on the merits. Okay. Don't like let me lose on some technicality here. So I would definitely not wait till trial, because you probably, well, I won't say that it's probably, there's a good chance you won't get to trial, because once those are deemed admitted, they can file a summary judgment and boom, you lose because you've admitted everything. So I would definitely look at handling that really, really quick. So good luck with that, and hope that you can get the judge to give you more time to answer those. See, Heather says, thank you. I've learned so much from you the past 4 years. Oh, well, you're very welcome, Heather. So glad to be of help. And let's see. I've got like 5 more minutes here. So Ace says, watch all your videos. Well, thank you very much. And need an attorney in Illinois. Okay, I'm going to type in a website, and you guys have probably seen this in my comments. This is for NACA. Hopefully that has popped up. Let me see here. Consumeradvocates.org/find an attorney. You can put in your state, and that's a really good place to go. And let's see, Beth, just file an answer to a debt buyer. Super nervous. Thank you for all your help. You're very welcome, Beth. Good luck with that. And I always recommend, even if you're not hiring a lawyer, get with the consumer lawyer in your state if you've been sued by a debt buyer. And at least what we do, I mean, somebody calls me in Alabama and says, I've been sued, I can't afford you, or I want to do it on my own. Will you talk to me? Sure. First of all, it's the right thing to do. Second of all, I want them to win, because then I want them to dispute on their credit report. And if it doesn't get fixed, then that's a fabulous lawsuit. I just had somebody send me a case like that this weekend where, guy wins his case, goes to the credit bureaus. Here's where I got sued. Here's the order where I won. Get it off. They didn't get it off. Hey, we're suing, all 3 bureaus, a couple of debt buyers. Those are fabulous cases. So definitely get with a lawyer just to get some advice in your state, Beth, and good luck with that. And let's see, Jerry says, thank you. And of all the voices of YouTube, clearly being the most credibility. Well, thank you. I appreciate that. I certainly don't know all the answers, but if I don't know it, I'll tell you that. And I appreciate it. And let's see, Maurice Scott here. 11th Circuit, does publishing include? That's a great question, Maurice. I was actually just thinking about that. Normally, we have always had like an actual, mortgage broker pull the report, but I think a soft inquiry would count. I don't know that. I haven't looked that up, but I think so. And so, if it's Capital One's reviewing your credit report, I mean, I've seen some account reviews that it's your full credit report. Now, they're not all that way, but I think that's a great question. And Maurice, if I am remembering right, I think you reached out to me, if you're who I'm thinking of, in Huntsville, and I sent an email and it came back. So evidently I got the wrong email. We must have written it down wrong, but reach out to me again through alabamaconsumer.com and let's talk. And so great question. Excuse me. So yeah, okay. So that I think we've talked about that. And so proximity marketer. So if Experian and TransUnion, let's see. Okay, I think this is the full one. Response back to dispute is verified, but the last status date is 2018. Does this look like my credit report did not get properly verified? I'm not sure. We'd have to know some more details of that. But sometimes the last status date is literally like, when's the last time anything's happened? I would make sure you're looking at a real credit report, so not like Smart Credit or Identity IQ, but look directly at Experian and TransUnion and see exactly what they say. And so I wish I had more time to help you with that, but you can always reach out to me and I'll see what I can do. And let's see, A says successfully bypass eOscar. Not really. I mean, eOscar is just their way of handling disputes between the credit bureaus and the furnishers. I like written, letters, because typically the bureau will scan that in and send the entire letter to the furnisher. So even if the credit bureau kind of messes up the automated stuff about what's the reason for the dispute, the furnisher can't really hide behind that if they have the actual dispute letter. That's the position I take. So I always like the dispute letters. And let's see, Burning Light, thanks so much for your education. Well, you are very welcome. And hey, guys, I've got to run. Really enjoyed it. Let me know if you like these. I'll do some more of these. And I'll try to grab any questions I'm missing. I'm not sure if they'll disappear when I click like in broadcast, but if I've missed anything, just put it in a comment or reach out to me at alabamaconsumer.com. So you guys have a great day and I'll talk to you soon. Okay, bye-bye.